Tim and Beth, you guys can see it?
Oh,
okay.
yes, I can. I'm so sorry. Yes.
That's okay. That's all right. All right. Well, welcome everybody to today's webinar. We have two amazing appellate attorneys here to talk to us about some very recent opinions that have come out from the Supreme Court. We have Beth Whitman, who works at Mark Gronzato PC. She specializes in state and federal appeals. She's a member of the appellate practice and the negligence law sections of the State Bar. She also serves as a member of the Standing Committee on Civil Procedure and Courts for the State Bar. She's a past chair of the appellate practice section and currently serves as its secretary. Beth is also a very new member of the MAJ and is a member of the amicus committee. And she's a board member of the Michigan Appellate Bench Bar Conference Foundation, which works to improve the administration of appellate justice in Michigan. We also have with us here today Tim Deemer from Jacobs and Deemer. Tim is a past president of the MDTC, the incoming chair of the negligence law section, and a partner at the appellate law firm of Jacobs and Deemer in downtown Detroit. And I've got one more slide here, I believe. Just so that everybody is aware, we do have some additional webinars coming up in the near future that are being put on by the negligence law section. We have Civility in Civil Litigation, a novel concept, which is on Thursday, September 14th. We also have Holding Effective Settlement Conferences, Best Practices for the Bench and Bar, which is also going to be by Zoom on Tuesday, November 28th. And our annual fall educational seminar is going to be held on Thursday, October 26th. This one will not be by Zoom. It will be in person at the Michigan State University Education Center in Troy, Michigan. And if anybody has any questions throughout the presentation that we are about to see, please, everything, okay. Please feel free to use the Q&A button at the bottom of the Zoom. I see we've got a greetings in there, but I will be monitoring that regularly. And if anyone has any questions, I will be sure to bring those up with the presenters. So with that, Tim, if you want to take it away.
Happy to. Thank you, Donna. Thanks everybody for attending. We have record attendance for a webinar. Over 240 people have signed up, which I think is a sign of just how momentous the most recent Supreme Court term was. It wasn't just momentous for negligence law lawyers like those of us on this at this meeting. The court issued major opinions on tax law, commercial law, on some auto supply company disputes, and Michigan's kind of the leader nationally on those issues. So the rest of the country is going to be looking to the Michigan Supreme Court on commercial law. But for our purposes, this was quite the term for negligence law. And I think that's why we have so many people here. Objectively speaking, I think the result of the most recent Michigan Supreme Court term is that we're going to have more jury trials and less judicial decision making, particularly dismissals on motion. That's going to be the theme you're going to hear from us throughout each of the cases we discussed today. More jury trials, less dismissals on motion. And my goal is to try to be as objective as possible, not to make value judgments on whether it's a good thing or a bad thing, just to try to report what's happened and maybe what's coming next. I can honestly say, and again, this is being objective, I passed the bar in 2002. And for the first 16 years of my career, Michigan was not a jury trial friendly system. The data bears that out, anecdotally that bears out. For example, in the year 2017, kind of last year before we had the big transition to a more jury trial friendly system, civil cases were 16 times more likely to be involuntarily dismissed than tried to a jury. And that 16 times more likely does not include settlements or arbitrations, but actual judicial decisions to dismiss a case on motion. 16 times more likely than to get your case before a jury. There are multiple reasons for why that was the case. One of them, and this is timely with the discussion of the Supreme Court term, the Michigan Supreme Court used to be much more inclined to reverse trial proceedings, sometimes even in a peremptory order, where a party takes a case to jury verdict, gets a good result, whether it be a jury verdict or no cause, and you could fight for 7 years and then have the Michigan Supreme Court reverse your trial proceedings and remand it back down to the trial court. And this would sometimes happen in a peremptory order without the benefit of full briefing, without the benefit of oral argument. You could see all this hard work go away in a 1-paragraph order. That was a contentious procedure, and it has come to a halt. That does not happen with the frequency it used to. By my looking back at previous Supreme Court terms, it does not look like the Supreme Court's reversed a civil jury trial in more than 10 years. So again, we have more free reign to try cases without the Supreme Court coming in and taking away a jury verdict or a no cause. Partly it's a reflection of just how few jury trials there were. But I think that's about to change. I don't think there's any doubt that that's going to be the result of the most recent Supreme Court term. We've already seen anecdotally again, more jury trials popping up. Some of it, there was a backlog during the pandemic. People are trying cases again. And I think as a reflection of what's happened in this most recent Supreme Court term, that's only going to continue. And this is going to be across a wide spectrum of cases, from medical malpractice, premises liability, workers' compensation, across the board. The Supreme Court's term covered a wide range of types of cases. And I think we're going to see that across the board: more jury trials, less judge decision making. And Beth is going to address one of those cases in the medical malpractice context.
Yes. Okay. So we will start with the Supreme Court's decision in Ottgen versus Katranji. So this case addresses the affidavit of merit requirements set forth in MCL 600.2912D. So a little bit of history going back to the year 2000, the Supreme Court issued its decision in Scarcella versus Pollock. And in that case, the Supreme Court held that the filing of a medical malpractice complaint without an affidavit of merit was ineffective to commence a cause of action and to toll the limitations period. So I think it's safe to say that Scarcella has been controversial in its holding, and many have questioned whether or not it was correctly decided. In fact, even Justice Viviano had indicated in some concurring opinions in the Supreme Court that he questioned whether or not Scarcella was correct. So in this Ottgen case, the plaintiff filed a medical malpractice complaint, but failed to file it with the affidavit of merit, and it was solely due to a clerical error. So the defendant sought summary disposition based upon Scarcella, and the trial court actually denied the motion, but the Court of Appeals then reversed the trial court and held that Scarcella applies, and that because the plaintiff had failed to file the complaint with the affidavit of merit, that there was no tolling of the limitations period, and plaintiff's complaint therefore needed to be dismissed with prejudice. So the plaintiff sought leave to appeal in the Supreme Court, and the Supreme Court granted leave in this case. So they did full briefing, full oral argument, and then issued a unanimous decision that was authored by Justice Viviano, and they reversed the grant of summary disposition in this case. And they held specifically that the filing of an affidavit of merit is not required to commence a medical malpractice action or to toll the limitations period. So they made it clear that an action is commenced by the filing of a complaint with the court, and that the limitations period is tolled once the complaint is filed, as long as the plaintiff serves the complaint within the time period set forth in the court rules. So the Ottgen court held that there's no support in any of the statutes, including the affidavit of merit statute, that actually supports the holding in Scarcella that plaintiff has to file the complaint and an affidavit of merit in order to commence the action and toll the limitations period. Now, the Supreme Court did not foreclose the possibility that dismissal could be granted with prejudice. They kind of gave an example of a plaintiff who would be a serial complaint filer without an affidavit of merit in order, in doing it intentionally to delay proceedings. And they said under those circumstances, dismissal with prejudice might be an appropriate remedy. But for an inadvertent or a quickly rectified failure to attach an affidavit to the complaint might not warrant such a harsh sanction. And of note, too, the court indicated prior decisions where even a dismissal without prejudice was not an appropriate remedy for a failure to attach an affidavit of merit to the complaint. So I think here, the takeaway in this case, well, obviously Scarcella is now gone after 23 years. And but really it's going to be that the failure of filing a complaint without an affidavit of merit is not going to warrant dismissal with prejudice based upon the statute of limitations grounds. So the trial court's now going to be left to determine some sort of sanction that would be appropriate. And I think that can run the gamut between no dismissal to possibly a dismissal with prejudice if there is some sort of an intent to delay proceedings. But but Scarcella is off the books after 23 years. So that's a big one. That's a big one. And I think it's been a long time coming too. So
very good news for those of us like
sure.
Fantastic. Right.
I think Ottgen fits the theme for today. That was a clerical mistake. The affidavit of merit was notarized and executed prior to the complaint being filed, but somebody screwed up and forgot to attach it. We've all made that mistake, filing something on an exhibit, something along those lines. And then rather seeing the most harsh sanction possible, dismissal with prejudice and an ability to file a potentially meritorious suit. The court kind of gave a free pass, no harm, no foul, refile your complaint and move on. One other thing I thought was interesting from that case is that it was a unanimous opinion. It wasn't a 4-3 or a 5-2 even, but it was also Justice Viviano's, it was based on concurring opinions he had issued in other cases. And you'll see that in a lot of the cases we discussed today, where one or two justices may have dissented or concurred and said, hey, we think there's another way to look at this. And then ultimately, sometimes years later, that view from a concurring opinion or dissenting opinion carries the day. Ottgen's one example of that. Another example of that is the case I was going to move on next. Unless Don have any questions popped in?
Nope, no questions. I think that one's pretty straightforward.
Okay, so the other, I think this may be one of the most high-profile cases. It's Elsayed, which was a consolidated premises liability case. There's Mrs. Elsayed is one plaintiff. The other plaintiff, Ms. Pinsky, I don't think anyone's going to know who she is. I think it's always going to be called the Elsayed case. Poor Ms. Pinsky's not going to get her 15 minutes of fame and have a case named after her. This was, again, consolidated cases, premises liability, 2 dismissals on the open and obvious doctrine. Pretty run-of-the-mill garden variety cases. Ms. Pinsky slipped and fell at a Kroger. Ms. Elsayed slipped and fell walking into a gas station. They both, she fell on snow and had her case dismissed. It was kind of a run-of-the-mill. We've seen these cases time and time again. Nothing really stood out to them. So that there are a lot of headlines from Elsayed and Pinsky. Obviously, the open and obvious defense has been eliminated as a kind of a C10 dismissal based on lack of legal duty. Further reflection that we're going to have more jury trials and less judicial decisions. Lugo versus Ameritech was overruled. There's no more special aspects doctrine in Michigan. Open and obvious is no longer a component of legal duty. It's now relevant to breach, whether the defendant breached the duty, and potentially a plaintiff's comparative fault. Those are the headlines, but I thought I'm a nerd and I read the opinion. I thought it was interesting to see how the court got to where it got. And the court went through more than 30 years of premises liability jurisprudence and kind of identified an original error from the first case, either I believe it was Riddle or Bertrand, kind of where this little tiny aspect of the opinion kind of blossomed and bloomed into what we had until Elsayed, the open and obvious doctrine, eliminating virtually all premises liability cases. And actually, we want to blame somebody, we can blame the drafters of the restatement for having confusing language in there. The first and second restatement, when they discussed open and obvious doctrine, said that a defendant is, quote, not subject to liability, quote, if the hazard was open and obvious. Not subject to liability could mean a million different things. It could relate to there's no liability because of duty, there's no liability because of breach, there's no liability because of proximate cause. It was unclear. And that was kind of where the court first started with open and obvious becoming a question of duty. And it was not clear from the restatement. Was it duty? Was it breach? If it was duty, open and obvious is a legal question. If breach, almost always breach is going to be a jury question. So I think part of the confusion is that the first and second restatements were drafted during the contributory fault era, where any amount of fault to the plaintiff would eliminate recovery altogether. That was a system that we had in Michigan until the 1970s. So under the contributory fault area, subject to liability didn't really matter if it was a duty question, a breach question, or a comparative fault question, because if there was any fault to the plaintiff, the complaint was dismissed in its entirety. Contributory fault was eliminated in Michigan in the 1970s. And we only had restatements from pre-1970s, pre-comparative fault. We had the contributory fault restatement questions. So the restatements were outdated, but our courts in the 1990s took the phrase subject to liability and construed it as a question of legal duty, as a defendant's duty, and the rest is history. Almost right off the bat, Justice Michael Kavanaugh, current Supreme Court Justice Megan Kavanaugh's father, and Justice Levin filed dissenting opinion after dissenting opinion, seeking to reorient open and obvious back to breach and away from the duty question. Justice Levin's dissents kind of would criticize the majority for turning everything into duty, taking cases away from juries, and that was the thrust of what his dissenting opinions were about. And over the course of decades, it culminated in Lugo versus Ameritech, where Lugo came out and said, open and obvious is not just a question of legal duty, it's an integral component of legal duty and premises liability. It's not some sort of an exception to the general rule of a duty of care. It's an integral component of it. And then Lugo also said open and obvious is not an exception, but then created exceptions to open and obvious doctrine of the special aspects, where there could be certain aspects about the open and obvious hazard that would still subject the defendant to liability. In my experience, I don't remember ever seeing a case where special aspects were found to negate the open and obvious doctrine. It seemed like there were these two exceptions thrown out there. I never actually saw them implemented, but that special aspects doctrine is gone. That's been eliminated under Elsayed and Pinsky. My personal thought is on page 32 of the opinions, kind of the money quote of Elsayed that gets to the heart of what the decision's about. And again, it fits the theme of the other case we're going to talk about today. And again, this is at page 32 of the opinion, where the Justice Clement said, situating the open and obvious analysis in duty, therefore poses two problems. First, it puts the judge, not the jury, in charge of deciding an issue that functionally includes an analysis of the plaintiff's negligence. But under MCL 600.2957, the liability of each person shall be allocated by the trier of fact, end quote. So again, comparative fault, open and obvious, that's for the jury. That's not for the judge or the appellate panel. And I think this switch, again, going back to Ottgen, where the court had been telegraphing Scarcella, we're going to overrule it. I think this switch that's recognized in Elsayed has also been telegraphed in a number of previous opinions from the court. One example would be the immediately preceding premises liability case from a couple years ago, Livings, where Chief Justice McCormick wrote a concurring opinion calling into question whether Lugo should be overruled. At that time, Justice Welch had just taken the bench and was not in a position to cast a vote in the case. And the speculation was perhaps had she participated in Livings, that maybe the Elsayed decision would have been made a few years ago, but that did not happen. But Justice McCormick's, again, her concurring opinion said Lugo is not working, special aspects is not working, and ultimately that view carried the day. There are two other cases where I think the change of focus from duty decision by the judge, breach decision by the jury was telegraphed in a couple of other cases. One of them is a case that Donna and Mark Gonzato worked on. Kermuth, I believe, was the name. It was a very tragic nursing home case. An elderly woman with dementia wandered outside in the middle of the night in the winter and could not get back in, and she froze to death outside. And the case, the way the case was litigated for all these years, I kept seeing the defense argument was, is there a duty for a nursing home to install alarms on a door? Is there a duty to impose special types of locks and have security systems? Really specific examples of things that were phrased as duty. And Justice McCormick, during the oral argument, raised that point and interrupted Mark Gonzato and said, why are we talking about such specific questions of duty? Whether the lock should have an alarm, whether the lock should be self-executing, those all sound like whether the defendant breached the duty of care. She raised it, didn't go anywhere with it. Mark moved on, and it was not necessary to decide that case, but I think that started to signify maybe the change in thought. Because, if you look at a case called Moaning versus Alfono, it's treated as the guidepost question of legal duty in Michigan law. I believe it's also from the 1970s. It's technically still good law, but if you read the opinion, it almost sounds like a foreign language compared to how we've seen, especially premises liability cases, decided on the question of legal duty. Under Moaning, legal duty is there any obligation whatsoever to another person? Not, is there an obligation to do these specific things or refrain from these specific things? So one example of it is, as a lawyer, I have a duty to my client, and I don't owe a duty to the opposing party or opposing counsel. I owe them absolutely nothing. So I have no legal duty to them, only to my own client. So if the opposing party gets mad at me, wants to sue, they can't, I don't owe them anything. That's the type of example where there's no obligation whatsoever to another person, but we transitioned into these highly specific formulations of what legal duty was. McMaster versus DTE is another case that I think further signaled the switch from duty to breach. There were two different legal grounds on which the defendant there could have had the case dismissed. The court didn't take either legal ground on the question of duty and said, no, there's no proof that the defendant breached any obligation it might have owed to the plaintiff. So again, I think this has been a long time coming, and Elsayed was kind of finally where we ended up with the transition from questions of legal duty to questions of breach. There's from Elsayed a couple of other open questions. The first is going to be, now that we're going to have premises liability trials, what's the open obvious jury instruction going to look like? I don't know if the model committee on civil jury instruction is going to get together and issue some sort of a model instruction right off the bat, or if it's going to be up to the parties to figure out. That's going to be a major fight. The other question, and this was, again, another telegraphed issue in Elsayed, there's been a third restatement that's come out on premises liability. And the court specifically said, we're not taking a position today on whether we're going to adopt the third restatement. That's a decision for another day. So somebody's going to present that issue to the Supreme Court, and the Supreme Court's going to have to decide whether to adopt the third restatement. And the third restatement's pretty revolutionary in a number of ways. There's no longer a distinction between invitee, licensee, or trespasser. The standard of care is the same as to all classes of persons. The only exception is a flagrant trespasser, whatever that means. I think that means if somebody comes to rob your home, they're a flagrant trespasser. If somebody unintentionally comes on your property, maybe they're just a regular trespasser. That's unclear. But for me, the biggest change is the language is no longer that a premises possessor can be liable for an unreasonable risk of harm. It's now any and all harm. So a completely reasonable harm could still be subject a premises possessor to liability. So the Supreme Court said, we're not going to decide whether to adopt that today. we're going to reserve that for a later date. So someone will be presented at Supreme Court, whether to adopt the third restatement for a decision.
All right. Okay. So I'm going to move on to the next decision. It's the Kostadinovski versus Harrington case. I've practiced that word so many times. Okay, so this case addresses the question of whether the pre-suit notice of intent requirements, which are set forth in MCL 600.2912B, apply where the plaintiff seeks to add new theories of malpractice against an already named defendant. So again, a little bit of history on this one. There's current case law that permits a plaintiff to correct any defects in their notice of intent under a different statute, MCL 600.2301, and that allows for amendment and disregard of any error or defect where the substantial rights of the parties are not affected and the cure is in the furtherance of justice. So that was a decision that came out from the Supreme Court in Bush versus Shabahang, and that came out in 2009. So the facts in the Kostadinovski case is that plaintiff sent a pre-suit notice of intent as required under 2912B, and they asserted 6 specific theories of malpractice against the defendant doctor. The same 6 theories of malpractice were included in the complaint as well as in the expert's affidavit of merit. But then during discovery, it was revealed that plaintiff's experts could not actually support those 6 theories of malpractice that were in the notice of intent and in the complaint. So plaintiff moved to amend the complaint to add a new theory of malpractice, one that was not originally included in those 6 theories that were outlined in the notice of intent. So the trial court actually twice denied plaintiff's motion to amend the complaint on futility grounds, given that the notice of intent didn't include this new allegation of malpractice. The trial court said that the amendment would run afoul of the requirement in 2912B that the plaintiff had to provide a notice of intent prior to filing the complaint. So the Court of Appeals actually ultimately affirmed the trial court's ruling and held that plaintiff's proposed amendment of the complaint would deprive the defendants of a substantial right, and that was the right to pre-suit notice and the opportunity to negotiate settlement without engaging in litigation, and also held that any amendment of the defect in the notice of intent would not be in the furtherance of justice. And that was one of the prongs in section 2301. So the court, this is the important part, I guess, the court also rejected the plaintiff's argument that 2912B doesn't apply at all to a party's attempt to amend a complaint to add new theories against an already named defendant. The plaintiffs had argued that 2912B simply requires the service of a notice of intent before suit's filed, and that once there is a statutorily compliant and timely notice of intent that's served on the defendant, the requirements of 2912B have been satisfied. So the plaintiffs then ultimately appealed to the Supreme Court, and the Supreme Court ordered a MOA, mini oral argument on the application. So the holding in this case is that the Supreme Court reversed ultimately the Court of Appeals and held that the notice of intent requirements in 2912B do not apply to an already existing defendant after a medical malpractice action has been commenced. The court noted that the whole point of a pre-suit notice, which is to promote settlement without the need for formal litigation, it can't be realized when there's already litigation that has been commenced. So the court concluded that under 2912B, the pre-suit notice requirement only applies before the medical malpractice action has been commenced. So because the plaintiffs in Kostadinovski had already commenced an action when they sought to amend the complaint, there was no basis for the trial court to deny the amendment of the complaint to allow the new allegation of malpractice to be included in that complaint. So that's the takeaway in this case. If a plaintiff seeks to add a new theory against an already named defendant, the plaintiff does not need to comply with the requirements of 2912B with respect to those new theories. So, this is, I think, just another technical expansion of Bush versus Shabahang, but it's just, again, kind of employing a more reasonable standard to these procedural requirements, like such as the affidavit of merit and the notice of intent, to allow these cases to go forward and not result in dismissal.
Beth, did the court say anything about whether the affidavit of merit has to be amended?
Well, we have case law that says that you can amend an affidavit of merit as well, and that the amendment would then relate back to the original filing. So yeah, we already have that hopefully taken care of. But so again, it just shows that the court has been, it used to be the failure to have an affidavit of merit that complied with statutory requirements, the failure to have a notice of intent that complied with statutory requirements. Your case was gone. It was a dismissal, and it was dismissed with prejudice. And the court has slowly taken that down to where it's a lot more reasonable. And, you're not going to lose your case because of procedural requirements, particularly a notice of intent, which I know is sent before you've ever had discovery, before you truly, truly know the facts of the case.
So best practices moving forward, if we are in this situation and we need to amend our complaint, would you suggest that we also attach an amended affidavit of merit to the amended complaint?
I think that's certainly not a bad idea. I think that's a good idea. And, but there is, the case law does, I think that actually the case law with respect to affidavits, I think it's a little bit more forgiving, and that you may not even have to do that. So, yeah.
Okay, fantastic. We did have a question come up about Elsayed, Tim, that you were talking about. And the question is really whether or not that opinion is going to be applied retroactively or prospectively, and whether or not you guys have an opinion as to how it's going to be applied.
The opinion did not say. My guess, educated guess, would be it's retroactive to cases that are pending now. And the clearest indication is there's no statement that this applies to claims filed after such and such date. And then also both of the plaintiffs in that case had their cases dismissed, and the Supreme Court reversed and sent it back to trial court for further proceedings. So my read is it's going to be retroactive. It's going to be, I remember when the Supreme Court issued its serious impairment decision in Cramer, it came out and then they issued all sorts of orders deciding all these pending appeals under the Cramer standard. And then when McCormick came out and went in a different direction, serious impairment did the same thing. All those cases that were pending had McCormick applied to it. So I don't see any reason why this would be prospective only. My view would be that this would be retroactive.
Yeah, I agree. I mean, obviously it doesn't foreclose people from making that argument, but I think ultimately it will.
Okay. So before we move on to the next one, I'm going to start announcing the case name and the case number because that information's been requested. And just to confirm, Tim, we're going to move on to Doe versus GM.
Yes.
All right. And that's Supreme Court number 163775.
Okay, thank you. Yeah. So Doe versus General Motors, not a highly publicized case. I doubt very many people even heard about it or let alone thought about it. It's a sleeper case, in my opinion, in terms of its importance. And maybe it's not as publicized and talked about because it's in the workers' compensation realm, which is an arcane niche practice. No offense to workers' comp attorneys. Doe versus General Motors is an exclusive remedy dispute. So ordinarily, if someone's injured on the job, their only remedies against is only through the workers' compensation system. You can't sue your employer unless you were intentionally hurt. There's an intentional tort exception to the exclusive remedy. 99.9% of the time, that's an example of a coworker coming down the hall and punching somebody. It truly means an intentional tort, not substantially certain, not reckless, not willful, not gross negligence. It truly means intentional tort. those cases are very, very difficult to prove. It's really tough to prove an intentional tort, especially in circumstances like that were at issue in Dover General Motors, where it was not a coworker punching somebody else. It was a machine that had malfunctioned on occasion in the past. And the plaintiff in Doe was injured by that same machine that had previously malfunctioned. Those claims can be pursued, but again, they're really, really challenging, where you have a machine or device or equipment that continually malfunctions in injured persons. It basically requires the employer to say, I know that machine's likely to malfunction, hurt this guy, and I don't really care. That's basically what someone would have to prove. And that's a really, really tough standard to meet. So in Doe versus GM, it was a malfunctioning piece of machinery. There was no proof it had hurt anybody else. There was proof it had malfunctioned in the past. And the plaintiff filed complaint rather than answer the complaint and go through discovery. General Motors filed a motion for dismissal on the pleading, saying no matter what the plaintiff might prove, might uncover during discovery, he's never going to show that this was intentional tort. Made its way up to the Supreme Court, and the Supreme Court reversed and said, you know, the plaintiff, you might not ultimately prove your case, but you're at least entitled to discovery. So from my perspective, that's a huge case, because if those types of claims with such a high burden of proof and such a difficult standard to meet, you still get discovery, C8 motions are going to be really, really tough to successfully argue, and maybe more difficult to sustain on appeal. If that claim can go forward, then almost any claim can go forward, unless it's the type of claim that a C8 motion is designed to weed out, something that on its face is so clearly unenforceable. The cause of action is not recognized under Michigan law or something along those lines. But if it's a valid cause of action, it's recognized under the law. Under Doe, you have the plaintiff, you have a really strong argument that you at least get discovery. You might not prove your case, but you at least get to do some depositions, do some discovery. So for the defense lawyer, maybe be careful what you wish for. C8 motions are valid. They're still in existence in the court rules, but they're not maybe as strong of a defense as you would have thought before Doe versus General Motors. So Doe versus General Motors is kind of a sleeper case to me. I think it's really important. I think the plaintiff's going to get discovery on almost all cases, unless it's so clearly enforceable on its face that it's subject to a C8 dismissal.
Okay, fantastic. Before we move on, we had a question about whether or not we are expecting any appeals of the open and obvious decision. Is that like something that a motion for reconsideration can be filed on, or?
Yeah, technically, although I'm not sure if we're past the 21 days by now. Decided July 20. Yeah, we're past the 21 days. So if there's a reconsideration motion, rehearing motion, it would have been filed already. Rehearing, reconsideration are always tough. I think they're going to be even tougher when you have an opinion that's over 100 pages long. Clearly, they thought a lot about this decision, put a lot of work into it, and it's not the kind of decision I think would be, you know, on second thought, what were we thinking? I don't think that's going to happen here.
I'm also getting some questions about, again, the case names and numbers. I am posting them in the chat, and I'm happy to circulate these links to these cases, or even the actual PDFs of the cases after the seminar. But as we go along, I will be posting them in the chat. And it looks like, did you want to do Andary next?
You know, I don't think that decision's that important. I think we should just skip past Andary and go to the next one. I'm just kidding, of course.
Oh, I'm just deferring to you too.
Sorry, I'm being 100% sarcastic. I have a feeling that's the case most people are interested in hearing about is Andary.
All right, well, before you go into it, let me give the Supreme Court number here. And I just had it. Okay, the Supreme Court number appears to be, I've got a docket number, but I don't know that this is the Supreme Court number. It's not on the top of this for some
I have
reason.
164772.
Yep, that's it. Okay, perfect. Thank you.
Okay, my bad attempt at humor. I think of all of the cases we're going to discuss today, Andary is probably the most publicized. No fault litigation is so extensive in Michigan and Wayne County. It's like 90% of the docket, basically. That this is the decision most people have been watching for this term. And surprisingly, it's a huge, important decision, but it is not the landmark decision maybe people were expecting. It doesn't signal a major shift in Michigan law, at least in my opinion. I think it's because the result is largely what most people expected it to be. The reforms to the no-fault system passed in 2019 are not going to be applied retroactively to people who had been involved in motor vehicle accidents and injured before the reforms. But at the same time, the reforms will be applied prospectively, and the reforms were not unconstitutional. Those were the two issues in the case. And I think this is what most people expected the decision to ultimately be. So it is important because there were various interest groups, some more on the plaintiff side, more on the defense side, arguing that the reforms were unconstitutional, they should be struck down, and we should go back to the no-fault system as it existed before. Providers in the Andary case made that argument that the reforms are unconstitutional, due process, equal protection grounds. The Supreme Court rejected those arguments. The Court of Appeals would have remanded to the trial court for discovery on the constitutional question. Supreme Court said, no, this is economic legislation. It had a rational basis. We might not agree with the reforms, but there was a basis for doing so. The goal to reduce auto insurance premiums was a worthy goal for the legislature to pursue. So they did not strike down the law as constitutional. Other interest groups, I believe it's amicus curiae, the Insurance Institute of Michigan, I think is who made this argument. They filed an amicus brief that said, if you strike down these rate reducing measures, then you've got to strike down all of the reforms, because without that part of the reform, the entire thing should be struck down. So the Supreme Court had these two big, huge nuclear options at its disposal, rejected both, issued a pretty narrow, straightforward ruling. Again, reforms not going to be applied retroactively, prospectively. The two reforms at issue in this case are constitutional. And the two reforms at issue in the Andary case were a limitation on the amount of time that a family member can provide attendant care for an injured person, and then also a fee schedule. Those were the only two reforms at issue in Andary. And obviously the reforms covered a wide variety of topics, but those are the only two that the Supreme Court actually looked at, and the Supreme Court affirmed both of them, so they're constitutional, applied prospectively. Maybe even though it was a decision that most people expected, the opinion did have to walk a bit of a tightrope. There was a recent decision by the Supreme Court, Miemick versus Fortson, which held that once a policy of no-fault insurance is executed, the party's rights are dictated by the statute, not by the contract. So that meant common law contractual defenses that occur, that might be raised for events that happen after the contract was formed, were no longer valid, because by the time the contract was formed, you now had a statutory cause of action, not a contractual cause of action. So that opinion was a major roadblock. And the reason it was a roadblock is because the legislature has a general right to revoke statutory rights, but has a constitutional prohibition to take away contractual rights. So probably the biggest issue the court in Andary had to face was how to reconcile the Miemick versus Fortson decision with what it ultimately decided in Andary. In Andary, the Supreme Court clarified its opinion and said that a entitlement or claim for PIP benefits is both statutory, as we held Miemick, but it's also contractual. So because it's contractual and statutory, and that phrase is repeated time and time again throughout the opinion, PIP benefits are statutory and contractual. So based on that ruling, the Supreme Court held that there would be a prohibition against a retroactive rescinding of contractual rights under an insurance policy. So that was a pretty narrow decision. Again, only two reforms were at stake. There are a lot of other reforms that were passed in 2019. So obviously there are going to be other challenges to the other reforms, and Andary did not answer directly how they would be judged by the Court of Appeals or the Supreme Court. My guess, my prediction would be that the other reformers would get the same treatment, that if the party in that case has a vested contractual and statutory right to PIP benefits, they cannot be retroactively taken away. But if the contractual and statutory rights did not vest until after the reforms were passed, then you're going to have the prospective application of the reforms. And the reason I believe that's how the court would decide future challenges, there seem to be, again, two major guideposts to how the court decided Andary. The first was the vested rights analysis. The court was a little bit ambiguous on the vested rights analysis. At one point, the court's opinion said that the scope of PIP benefits was decided by the state of the law at the time of the automobile accident. And in Andary, the two injured parties were involved in car accidents years before reforms were passed. So that was a pretty easy hurdle for them to meet. But at other times of the opinion, the court said that the law in place at the time the contract was executed controls. So those two timeframes might be different. You could conceivably have a contract executed under the old no-fault system, and then the injury occurred after the reforms have been passed in June of 2019. So what Andary did not decide, and he specifically raised this question of which law is going to control. Is it going to be the law at the time of the contract, or is it going to be the law at the time of the accident? And Andary, they said, we don't need to address that because these accidents happened so long ago. We don't even need to address that. So I think you're going to see a number of cases with that fact pattern. 2019 policy, but the accident occurred after the reforms were in place in June of 2019. I think that's going to be a major fight that we're going to see in the no-fault world. And the other guidepost, and it's related, in my opinion, to the court's decision in Andary, is what are the expectations of the parties at the time the contract was formed? So the two plaintiffs in Andary, they were involved in horrific accidents years before reform was passed, years before reform was even on anyone's radar. So to apply a law that might have occurred 10 years later to something that happened 10 years before, that does not meet their expectations. When they entered those contracts, the law was the law at that time. So it makes sense to enforce their expectations at the time the contract was entered into. But again, what about somebody, what's the expectation of somebody who might have paid for a no-fault policy in 2019? And maybe their expectation was, I know what reforms are going to come down the road. But then the accident happens after the reforms were ultimately passed. What's going to prevail? The expectations of the parties at the time of the contract or the state of the law at the time of the injury? I think that's going to be a major fight on those cases. On future cases. One other issue that stuck out to me in Andary is the problem with the no-fault system from its inception has been we have a compulsory insurance scheme, but we also have really, really expensive insurance premiums. And that tension between those two has been there from the start. If anything, it's probably only gotten worse. So the Andary court still noted that there are constitutional problems if we have exuberant auto insurance rates and still a mandate to purchase auto insurance. That might pose constitutional problems going forward. So for a defense lawyer's perspective, my recommendation is that remains a pretty strong public policy argument you're going to have if you're trying to argue something, your position to say that the rates have got to be brought under control. Otherwise, we're going to start to have constitutional problems. So that piece of Andary is still out there and it's still available to defendants to make that public policy argument. Unless there's questions, I was going to transition over to Beth to discuss kind of similar to Elsayed, another case where the law, technically still good law, but it's kind of unrecognizable years later after a death by 1,000 paper cuts.
Mm-hmm. Yes, exactly. So the next case that we're going to talk about is the.
I'm so sorry.
Oh,
Before you move on, we did have
of course.
Tim, do you have an opinion about PIP benefits that are 100% statutory and whether or not reforms can be applied retroactively to those benefits?
Under the court's opinion, if it's 100% statutory, you at least have an argument. If it's contractual, I think that forecloses any contractual entitlement to PIP benefits. I think the retroactivity issue is off the table. That's my read. If it's purely statutory and there's no contractual right, then I still believe you have that argument to argue retroactive application. You might not succeed, but Andary is not going to be an obstacle to making that argument. You might lose for different reasons, but Andary is not going to be a problem. And I just got a correction, Andary. Okay. I got a comment that my tie was crooked. Now I get a comment that's not right. So anything else, feel free to send a message.
All right, the next one we're going to move on to is Markel versus Beaumont Hospital.
Yes.
The case number is 163086, and I'm going to post a link to it in the chat.
All right, thanks, Donna. Okay, so this case addresses the issue of ostensible agency in a hospital setting. So where a patient seeks treatment at a hospital emergency room and is treated during their hospital stay by a doctor with whom they have no pre-existing relationship. So again, a little bit of history that goes back a ways. The seminal case that establishes ostensible agency liability in an emergency setting is Grew versus Mount Clemens General Hospital. I have also heard it pronounced as Grewy. I say Grew, so I don't know. To correct me in the comments, that's fine. In Grew, the Supreme Court held that in order to establish a claim of ostensible agency, a plaintiff must show three things. First, the person dealing with the agent must do so with a belief in the agent's authority, and this belief must be a reasonable one. Two, such belief must be generated by some act or neglect of the principal sought to be charged. And three, the third person relying on the agent's apparent authority must not be guilty of negligence. So in this case, Ms. Markel filed a medical malpractice action arising out of care and treatment that was provided to her at Beaumont Hospital after she sought emergency treatment from the hospital. So plaintiff sued Beaumont Hospital and Dr. Lonapin, who was a physician who it was a hospitalist, so only provided care and treatment in the hospital setting. And Dr. Lonapin was provided to Ms. Markel based upon an agreement between Ms. Markel's, her employer and Ms. Markel's primary care physician, Dr. Bona, who had an agreement that Dr. Lonapin would then treat all of his patients at the hospital. So part of the allegations in the complaint was that the plaintiff alleged that Beaumont was vicariously liable for the acts of malpractice by Dr. Lonapin. So Beaumont then moved for summary disposition as to the vicarious liability claim, saying that there was no reasonable belief that plaintiff could have that Dr. Lonapin was in fact an ostensible agent of the hospital. The court noted in its opinion that Ms. Markel had testified that she had no recall whatsoever of Dr. Lonapin during the time that she was treated in the hospital. So based upon that fact, the trial court held that she could not have had a reasonable belief that Dr. Lonapin was acting as a hospital agent. The Court of Appeals affirmed the trial court's decision in an unpublished decision, and then plaintiff sought leave to appeal in the Supreme Court, and the Supreme Court granted leave. The Supreme Court then issued an order reversing, and it was just an order. It was not a full opinion. It was an order reversing the Court of Appeals decision. So the court really went back to the decision in Grew to issue its ruling in this case. And the court held that the critical question that was identified in Grew was whether the plaintiff at the time of his admission to the hospital was looking to the hospital for treatment of his physical ailments or merely viewed the hospital as the situs for where he would obtain the care and treatment from his physician. So the Markel court held that consistent with this holding in Grew, a patient who has clear notice of the physician's employment status, or who has a pre-existing relationship with the physician who is providing care and treatment, they cannot have a reasonable belief that the physician is an employee of the hospital merely because the treatment was being provided within that hospital. But under Grew, The court emphasized that when a patient presents for treatment in a hospital emergency room and is treated during the hospital stay by a physician with whom they have no prior relationship, a belief that the doctor is the hospital's agent is reasonable unless the hospital does something to actually dispel that belief. So the court said, put another way, the act or neglect of the hospital, which is under that second prong of the GRU test for ostensible agency, the act or neglect of the hospital is operating an emergency room staffed with doctors with whom the patient has no prior pre-existing relationship. So there was a whole line of cases that had come down from the Court of Appeals, Van Stel being probably the main one, that had kind of held that that the plaintiff would have to show some sort of additional affirmative act by the hospital that would create in the patient's mind the reasonable belief of agency in order to actually prove an ostensible agency claim. But the Supreme Court said that those cases are overruled, they're in conflict with GRU, and they therefore are no longer good law. So Van Stel has been overruled. And that's a big deal because Van Stel, I think, is probably the main case that most defense attorneys rely upon in order to argue in their C-10 motions that there is no basis for ostensible agency. So of note too, the court also addressed the lower court's holding that because plaintiff couldn't recall Dr. Lonapin, she couldn't have formed a reasonable belief that the doctor was the hospital's agent. The court held that this also is in conflict with GRU because if a patient presents to the emergency room for treatment and is admitted to the hospital for emergency care and looks to the hospital for treatment, the patient's belief that that physician is the hospital's agent is reasonable unless dispelled in some way by the hospital. So the Supreme Court then remanded the case back to the Court of Appeals, and that's where they are right now. The parties have filed supplemental briefs in the Court of Appeals, and we are now waiting a new decision from the Court of Appeals on remand. So the big takeaway on this one is following Markel, I think the question of ostensible agency is going to be one for the jury. I don't think that C-10 motions are going to be granted like they used to be all the time. So, with Van Stel being reversed and GRU really being emphasized by the Supreme Court as the law of the land in Michigan, I think that those C-10 motions are not going to be granted, and we're going to go to trial on questions of ostensible agency.
This is also very helpful in a case where someone goes into the ER and dies.
Yes, that was another point that the Supreme Court made, is that you don't even need testimony from the plaintiff in order to establish ostensible agency. So, and there is a line of cases that came out from the Court of Appeals as well, talking about if somebody comes in, if they are incapacitated as well, that they couldn't form a reasonable belief. So I think those cases, as well as the cases where the plaintiff dies, I think those are probably going to be, an issue of fact for the jury.
Great. That's good news. Okay, so the next case that we're going to talk about is Cramer versus Transitional Health Services of Wayne. This docket number for the Supreme Court is 163559, and it will go in the chat momentarily if it's not there already. No, it's not. Okay.
Then Beth, I started to ask a question, but I had myself on mute. So ask you a quick question about the GRUI decision. Is there any instance where that would apply in a non-emergency room setting, or is it only for emergency rooms? Because you kind of just get to the hospital and you're not really that concerned with who's treating you, perhaps maybe the individual person would be. Will that apply to other instances where a doctor might have staff privileges at a hospital but not be an employee of that hospital?
Yeah, I think it's all going to depend on the facts of the case. If you perhaps are in the hospital, but because your primary care physician, for example, has privileges there and you're seeing your primary care physician, but then something else comes up and there is a physician that comes in and treats you, I think you may have a potential argument that you are looking to the hospital to provide that physician, and you're looking to the hospital for that care and treatment. But that type of situation is not specifically addressed in GRU, nor is it specifically addressed in the Markel decision. But, I think there's arguments that certainly can be made. And I think there's going to be a lot of arguments now too, that, what is going to be sufficient to dispel that belief? How much information, if you give the patient, is going to be enough so that they no longer believe that somebody is an agent, an ostensible agent of the hospital. We see a lot of times the consent forms that were signed, but a lot of those consent forms aren't very clear. They're not very specific. So is that going to be enough under certain circumstances to say that the hospital has dispelled the plaintiff's belief, and whether or not a physician is acting as the hospital's agent? Yeah, I don't know, but I think there definitely going to be more questions of fact that are going to be decided by the jury.
We also got a message here that there is that issue. I'm not sure which issue, but one of them that we've been talking about is now on appeal in, and I'm going to not say this name right, Grzywacz, GRZYWACZ versus Crittenton.
Okay. So, and we'll see too what happens with Markel in the Court of Appeals. They still have to decide whether or not, based upon the GRU framework that was reaffirmed in the Markel decision, that, whether or not there was this reasonable belief and whether that was maintained. So.
And I've just got a little more clarification on that Grzywacz case. The issues that are up on appeal are the consent form and a later treater coming in days after the ER admission. So that's good.
Okay, well, so we'll see what those cases then hold. And but this really opens things up, I think, a lot for plaintiffs to get to a jury on this question.
Agreed. You want to move on to Cramer?
Happy to move on to Cramer. It's another workers' comp case. We love workers' comp. This one's this one is a workers' comp issue. Dover General Motors was more how the workers' compensation system exists in general civil litigation. Cramer was a workers' comp dispute, and the claim of a plaintiff, I think they're called claimants, to workers' comp benefits for the aggravation of a pre-existing mental injury. And the details of the case are interesting, but again, for me, what's most interesting is that the decision of whether a pre-existing injury was aggravated sufficiently to entitle somebody to comp benefits for workplace injury, that had been dictated by the Comp Bureau in a 2001 decision issued by the Comp Bureau. The Supreme Court, 22 years later, looked at the administrative agency tasked with implementing the statute and told the administrative agency that you got it wrong. Your administrative interpretation of the workers' compensation statute does not fulfill the promise of the workers' compensation system, which is to be liberally construed in favor of providing compensation to injured employees. So for me, it's less the minute ruling that, hey, the case of Martin versus Pontiac School District was wrong and decided for the following reasons, but the fact that the Supreme Court took it upon itself to reverse a long-standing precedent of an administrative agency. So with Elsayed, the Supreme Court overruled its own precedent. In Markel, the Supreme Court reinvigorated a precedent that was still technically good law but had not been followed. The decision to step in and overrule the administrative agency charged with implementing workers' compensation statute, that's the headline to me. So you might have in your practice some case you're really unhappy with. It could be 20 plus years old and you really don't like it. This is a signal to you. If you don't like that decision, seek a change in the law. You can file your appeals. You can say the law is against me now. I'm going to seek to have the Supreme Court change it, and you might get somewhere. Again, Cramer is a 22-year-old Workers' Compensation Bureau decision. The Supreme Court set it aside, reinstituted a new rule of law. So if that's on the table, then I think any precedent you don't like is going to be on the table. One other note from Cramer versus Transitional Health Systems and how they got to that decision. Going one step back, Kostadinovski, if I pronounced that right, I thought it was interesting. The Supreme Court looked to the legislative history of the statute when making a decision. It's been a long time since the Supreme Court looked at legislative history. That was kind of off the table because we're only going to talk about the text. In Cramer, this is more of a textualist argument to tie the two together. The Cramer decision, in my opinion, does not bode well to the current challenges to governmental immunity. One of the major issues that I know the plaintiff's bar has with governmental immunity is the fact that the proximate cost standards are higher. To recover against a governmental employee, the plaintiff must show not just that the misconduct was a proximate cause, but the proximate cause, meaning the most efficient, most direct. That's a tougher standard to meet than just a proximate cause. And I know that fight's been waged in a number of cases to try to relax that language from the proximate cause to a proximate cause. If I'm a defense lawyer representing a governmental entity in facing that argument, the reason the Cramer opinion made its decision is because the statute at issue there said that the new event must be a significant factor in the injury. And Martin, the case that was overruled, was interpreting as the significant factor, meaning the most important one. So in Cramer, went to textualism, A means one thing, the means something else. So in Cramer, that was a pro-worker, pro-compensation ruling based on the difference between A and the. We have the exact opposite in the governmental immunity issue, where it's the proximate cause. So if I'm reading Cramer, I don't think that argument's going to go anywhere. The Supreme Court's going to overturn Robinson University of Detroit and say, well, I know the statute says the proximate cause, but it's actually a proximate cause. This does not bode well for that challenge, which I know has been made in many cases.
Got it.
All right.
The next one, you want to talk about Wilmore-Moody?
Sure. All
Okay.
right.
So the just so that everyone has the Supreme Court docket number, it's 163116.
Excellent. Okay, so this case, this one's pretty straightforward. This case involved the effect of rescission of a policy of insurance on MCL 500.31352C, which prohibits a person from recovering third-party benefits for injuries resulting from a motor vehicle accident if the person was operating their vehicle at the time of the injury and did not have the required insurance policy in effect at that time. So the plaintiff and her 12-year-old son were involved in a motor vehicle accident. They were rear-ended by Mr. Zakir. At the time of the accident, plaintiff did have a policy of insurance issued by Everest National Insurance Company. So she had indicated on her application for insurance that she had identified all members of her household over the age of 14, which turned out to not be accurate. She lived in the same residence with her daughter and her daughter's children, one of whom was apparently over the age of 18. So because of this fraud in obtaining the policy, Everest rescinded the policy of insurance after the motor vehicle accident and denied all claims under the policy. So plaintiff filed suit against Everest seeking first-party benefits and also filed suit against Mr. Zakir seeking third-party benefits, claiming that he was at fault in the accident. So Everest filed a motion for summary disposition based upon the fact that it was entitled to rescind the policy because there was fraud in the original procurement of the insurance. And the trial court agreed. So following that ruling, Mr. Zakir then moved for summary disposition and said, hey, plaintiff didn't, it's been rescinded, so plaintiff didn't have insurance at the time of the accident, and that then precludes her third-party claims against him pursuant to 31352C. And the trial court agreed and granted Mr. Zakir's motion for summary disposition. The plaintiff appealed, and the Court of Appeals affirmed the grant of summary disposition as to Everest, the insurance company, but reversed the grant of summary disposition as to Mr. Zakir holding that plaintiff did have insurance at the time of the motor vehicle accident and at the time of her injury. So the barred recovery in 31352C does not apply. Mr. Zakir filed an application for leave to appeal in the Supreme Court, and the Supreme Court issued an order granting a MOA in the case. And then the Supreme Court affirmed and held that an insurer's decision to rescind a policy after a motor vehicle accident does not render the insured as having had no fault benefits at the time of the accident pursuant to 31352C. The court held that Ms. What's her name? Ms. Moody, Wilmore-Moody, there you go. She did have insurance at the time of the accident. And, you know, Mr. Zakir, who was a non-party to the contract between Everest and the plaintiff, was not entitled to use Everest's rescission of the insurance policy against the plaintiff's negligence claim. So, you know, pretty straightforward. The subsequent rescission of an insurance policy isn't going to render the plaintiff essentially uninsured for purposes of obtaining third-party benefits. And then I have the last one as well, unless there are any questions on that decision.
No questions. And is it Woodman?
Yes, Woodman. Yep.
So the case numbers are 163-382 and 163-383.
All right. So this case, again, I think it's pretty straightforward. This case addresses the availability of attorney fees in the context of the Michigan Freedom of Information Act. So the plaintiffs in this case, they're actually journalists, and they had they had submitted requests under FOIA for video and audio recordings from the Michigan Department of Corrections involving a fatal altercation that occurred at a correctional facility. So the defendant denied the requests straight out, asserting that they were exempt from disclosure under the penal security exemption under FOIA. So plaintiffs were then represented by the ACLU and by the Ottgen law firm, and they filed complaints in the Court of Claims arguing that they should be entitled to the video and audio recordings. The Court of Claims agreed and ordered the defendant to produce the audio recordings and produce these redacted video recordings of the altercations to the plaintiffs. So the Court of Claims held that the plaintiff had, in fact, prevailed in full in the FOIA action and therefore was entitled to statutory attorney fees. The court awarded the ACLU 100% of the fees that they had requested, but only awarded Hahnemann 10% of its requested attorney fees because it represented the plaintiffs on a pro bono basis. So the Court of Appeals reversed actually the Court of Claims decision that the plaintiff had prevailed in full, and held that because the plaintiffs only received redacted forms of the video recordings, that they had not in fact prevailed in full, and then remanded it back to the Court of Claims for a determination as to whether or not plaintiff would be entitled to any attorney fees at all because they were partially successful in their claims. So the plaintiffs then filed an application for leave to appeal in the Supreme Court, and the Supreme Court ordered a MOA in that case as well. And the Supreme Court actually reversed the Court of Appeals holding that and found that the plaintiffs had in fact prevailed in full by obtaining both the video and the audio recordings of the altercation. And it didn't matter that they had obtained redacted video recordings that had blurred faces of some of the prisoners and the security guards, that didn't change the fact that they prevailed in full. And that because they had then prevailed in full, they were entitled to a reasonable attorney fee. And the court held that flat out pro bono representation is never an appropriate factor to consider in determining the reasonableness of an attorney fee because it's just not relevant. It's not relevant to that question. So, so the court reversed the Court of Claims decision affirming the attorney fees award to Ottgen on the basis of Ottgen's pro bono representation. So So that's just the takeaway. Pro bono representation does not deprive you of the right to a reasonable attorney fee, whatever that may be.
It's good news.
Yes, yeah. For people that take these cases, this is a, they talk about these statutes as being a fee shifting type of thing. We want people to bring these claims because they're entitled to these public documents, and it may be difficult to find representation if there is not this fee shifting provision that's in there. And we should make that mean something. So that's it.
Well, good. It doesn't look like we have any questions in the chat. If anybody, those are all the cases that we were planning on talking about today. If anyone has any questions, we'll give you a minute to get those submitted, and then we can answer those questions.
Maybe while we wait, I'll go on a little bit of a rant while we wait to see if any questions come.
Good.
No, I'm just kidding. Not really a rant, but for the longest time we've been hearing. Again, speaking for the defense side, that clients and insurance carriers won't trust anyone to try a case other than an old white guy. And that's been a major problem for the defense bar of what's going to happen when the old white guys retire and we have a generation or two of lawyers with no trial experience. That's been a hypothetical problem in Michigan because we have had so few trials here that has not been a problem. There have been enough old white guys to try those cases, but that's going to change the number of cases that are going to be tried now. We're going to have younger, less experienced attorneys being put in a position of having to try cases. And I think the appellate system is going to have to reassert itself in terms of what is fair, what's fair game, what are the rules of engagement for trial procedure. Because for the longest time, again, the Supreme Court of Michigan has not reversed a civil trial in more than 10 years. Last one I know was Pellegrino versus Amco, which was a voir dire defect in 2010. I don't know of any Supreme Court decisions since then. Court of Appeals has issued a few. So when we have trials go sideways, we're citing Gilbert from the 2000s, Balamente, all these cases that are now 20 years old. There's nothing new, there's nothing recent. And anecdotally, it seems like the trials either are a no cause or they're an outrageous jury verdict. There's no in between. There's no compromise verdicts. The plaintiff either gets nothing or a boatload of money. So we're going to have a lot of really disgruntled litigants. Plaintiffs who got no cause are going to say the defense lawyer broke this rule, violated that law, and defense lawyers, when we have an outrageous jury verdict, are going to try to rein that in. And we're going to have these cases now going up to the appellate system. And I think the appellate system is going to have to reassert what the rules are for a fair trial. So we haven't had a lot of those decisions because we haven't had a lot of trials. I think that's about to change.
I agree, Tim. Any cases that are coming up through the pipeline that we should be keeping an eye out for?
Yeah, I actually wrote down a couple that I think should be on everyone's watch list. The Supreme Court issued a MOA, or they issued an order granting a MOA in the Danhoff case, and that case involves Daubert for standard of care testimony. And after the MOA, the Supreme Court just granted full leave. So that goes on now for next term. They will issue a decision by the end of July of next year. And so that's definitely one to watch, talking about the reliability of testimony and what you have to show to establish the standard of care testimony is reliable. So that's one issue. That's a big one. El Jamali is another one that is pending in the Michigan Supreme Court as well. And that one has to do with the common work area doctrine. So for all the construction cases, that's going to be a big one as well. In Robinson, Tim had mentioned Robinson as well. I think that one, I think is going to be one to watch, see if, what cases are going to come up. I don't know if anything's going to necessarily get up there this next term, but that's I think that's definitely a watch type of case as well. Tim, I don't know if you have any thoughts too.
Yeah, I know government immunity, again, maybe will be proven wrong. There have been some softening of government immunity rules. But I've also seen some really good cases to present changes to governmental immunity, and they haven't gone anywhere. So I'm a little less optimistic that optimistic may not be the right word, less convinced that governmental immunity is going to change. Premises liability has been reinvigorated. There's this area of law, many of you may have never heard of it, called products liability, where you're injured by a product and you can sue. We have not had products liability in Michigan. Maybe there's room for products liability law to be reinvigorated. I know there's a big, huge dispute for everybody that everybody's got a stake in is going to be damages in wrongful death cases. The wrongful death statute had been interpreted and construed as providing a limited category of damages that were available. And now that's starting to be treated more of as a including but not limited to type of category of damages. And those are starting to expand. I think that's a big issue that we're going to be seeing. And then there are, again, I was saying no precedent is sacred. Go after a case or decision you might not like. I know there's a strong movement to try to deem damages caps unconstitutional. That's got its own host of collateral problems. If that were to happen, I'm not just talking about insurance coverage rates and cost of goods, those kinds of things. But that opens up a whole other can of worms. But I know that movement is out there to have damages caps in med mal, product liability, anywhere else deemed unconstitutional. Nothing has been granted, nothing's been decided, but I know that is going to be a major push as well.
Yeah, I agree.
Just to share, there's some chats going on about no fault attorney fees. There's also as something to look for that's coming up. Also, another issue that's going to obviously be percolating soon is going to be the COVID tolling arguments. Also, probably COVID immunity, I would assume, is going to be headed up there in the near future. So those are some other ones to look out for.
Yeah. Yep. And the Supreme Court actually did grant, I believe, leave. I don't think it was a MOA in some of those COVID tolling cases. So that will definitely also be decided in this next term.
Well, good. That's great. You guys, thank you so much.
Yes, we'll be busy next year too then. That's great.
It was so informative and you guys presented it in such a great way that it makes sense to even non-appellate lawyers like me. So I appreciate you guys. And thank you. Hopefully we'll be back and do this after we get a bunch of opinions next year.
All right. Sounds good.
Hey, thank you, everybody. Thanks,
okay.
Donna.
Thank you so much.
Bye.
Okay. Bye-bye.